Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 66 of the NC DWI Guy podcast. On today's episode, we are doing a DWI update, the 2021 DWI update. We're actually going to be going back till about 2019 in terms of cases, and then working our way up to the present with a case update. This podcast is intended primarily for criminal defense DWI practitioners, and therefore we're going to be looking at the cases through that lens. So I'm going to touch on some cases that are both helpful and hurtful to the defense when it comes to DWI cases, but we're going to be looking at it through the lens of a criminal defense practitioner because that's what's going to be most helpful. Just want to remind everybody out there that if you do have a specific case that you'd like to get a second opinion on, we have attorneys throughout the state of North Carolina at the office. We have offices in Asheville, Hickory, Gastonia, Greensboro, Raleigh, Smithfield, Wilmington, Jacksonville, Concord. So if you have a case that you want to bounce an idea off of, give us a call. We'll be happy to talk to you about it. Hopefully there's somebody that kind of is in your area that you can bounce the case off of. So if we don't have anybody from our office in your local area, it's going to be better to find somebody that is in your neck of the woods because they're going to understand the local process and procedures better have a sense of the DA's office, judges that are sitting on the bench. So you'll be better served talking with somebody that is local. But if you have somebody that you'd like to bounce a DWI case off of, we are here to walk through that. So today we are talking about the DWI case update. And so I'm going to be hitting the highlights of cases. I'm not touching on every single case that has been decided in the last couple of years that has DWI as the charge or is necessarily relevant to DWI, but we're going to be hitting some of the highlights. So jumping right into it, a case from earlier this year, March of 2021, State versus Mackey. So this is a case in which the court was looking at checkpoints, and we're going to walk through these cases, not in the chronological order that they were decided. We're going to walk through them kind of in terms of how they touch upon substantive or procedural issues as it relates to how the case will be processed. So we're going to start with stop issues, then move on to probable cause, walk through motions to dismiss, cases that touch on jury instructions and on sentencing. So we're going to walk through it in that procedural order as opposed to chronological order. So State versus Mackey, the court was looking at checkpoints. And so if you have a checkpoint case, this is just a good case to add to that trial bag for checkpoints because they do walk through the proper primary programmatic purpose that we've talked about on the podcast a couple of times. But it also specifically focused in on the location of the checkpoint changing. In the State Highway Patrol plan, the troopers had in their plan indicated that the location of the checkpoint would change several times during the checkpoint. Didn't necessarily give a whole lot of details about specifically where each locational change would be made. And maybe there are some ways to distinguish a case if you have a checkpoint that changes locations. But the reason that the troopers did this, the reason that there was a change of location was due to the fact that the Waze app, and I'm not necessarily familiar with this app, but it's a location-based app on the phone. The Waze app could actually identify checkpoint locations. And so they're moving the checkpoint around to avoid any apps on a person's smartphone being able to identify where a checkpoint might be. And so even though that wasn't necessarily the central issue of the case, I think that that is going to be a major issue moving forward. As technology with smartphones gets better, this is going to be something that is going to be in more and more checkpoint plans. If you're doing a 2-hour checkpoint at the same location, I would expect that it's going to be highly likely in the near future for multiple applications on a smartphone to identify the location of that checkpoint. And so moving it around, I think, is something that law enforcement is going to use more and more. The court in this said that the location of the checkpoint changed several times, but this did not impact the validity of the checkpoint because the checkpoint location changes were planned in advance. So just be aware that that case is out there. If you see a change in location, I would first of all determine if in the checkpoint plan that locational change is allowed, and then look at distinguishing your case from State versus Mackey. So next, we have a community caretaking case, State versus Brown from April of 2019. So we have going all the way back to 2014, State versus Smathers, which was kind of the initial look at community caretaking by the North Carolina courts and adopting a community caretaking exception to reasonable suspicion being required to stop a vehicle. And so in this particular situation, community caretaking, State versus Brown, we have the court distinguish from the facts that were present in State versus Smathers to decide that the community caretaking exception did not apply in this case. And so the facts of State versus Brown were that the officer was standing outside his patrol vehicle when the defendant's vehicle drove past, and the officer heard an expletive coming from inside the vehicle. The officer indicated that he was concerned that there was an argument or possible domestic violence situation occurring, and got in his vehicle and caught up to the defendant's vehicle and ultimately initiated a traffic stop. So he ultimately gets in his vehicle, pulls him over. And again, this is all based on him standing outside his vehicle, defendant's vehicle passed, from defendant's vehicle, he can hear an expletive being shouted, thinks there's possible argument or domestic violence situation, and he initiates a traffic stop based on that. Could not see clearly inside the vehicle, couldn't see how many people were in the vehicle, whether or not there was any physical harm that was actually occurring. This was a relatively quick stop based on what the officer heard. So the court, and I think that the reason this is good is twofold for the defense. First of all, we have a situation where the court has said, no, community caretaking does not apply in this particular context. So obviously that's a win. Ultimately, the court found that this was an unlawful seizure. But secondly, and I think more importantly, the language from State versus Brown is really helpful when it comes to the community caretaking doctrine. So the court said that the community caretaking, quote, exception should be applied narrowly and carefully to mitigate the risk of abuse, end quote. Maybe that's the starting point for all arguments based on the community caretaking exception, where the state is arguing that community caretaking applies. Maybe pulling this specific language from State versus Brown, quote, the community caretaking exception should be applied narrowly and carefully to mitigate the risk of abuse. Really important, I think, for the court to see that. Secondly, therefore, cases where the community caretaking doctrine has been held to justify a warrantless search unquestionably suggest a public safety issue. There are no such facts in this case. So whether or not there is a public safety issue was central to the court's holding. They found that there was no public safety issue in this case, and therefore the community caretaking exception should not apply. Moving on to reasonable suspicion, we have another case from 2019, State versus Carver. In State versus Carver, the police responded to an anonymous call about a vehicle being in a ditch, possibly connected with a drunk driver or someone intoxicated. So this is going to focus in on anonymous tip. What does the anonymous tip say? Well, it says basically what we hear in a lot of anonymous tip cases. There's a possible DWI going on. There's a possible intoxicated person, possible drunk driver. The caller also said that a truck was attempting / getting ready to pull them out. So basically, they saw somebody that they believed was a possible drunk driver, vehicle in a ditch, truck trying to get them out. Police received no further information about the car, the truck, or the driver. They did get information about the location of the accident and found a white Cadillac partially in someone's driveway at an angle. The vehicle had mud on the driver's side. The responding officer did not observe anyone in or around the vehicle as he passed. As the officer continued driving past, he observed a truck a couple of 100 feet from where the Cadillac was parked, traveling away from his location. When he caught up to the truck, he estimated the truck was traveling 15 to 20 miles under the posted speed limit, and it was big enough to pull the car out. The officer then initiated a traffic stop. So the officer responds to the area that the caller made, sees a white Cadillac parked oddly in near a driveway, sees a couple of 100 feet up ahead a truck that was big enough to pull a car out, and therefore stops the truck, thinking that this may have been a truck that attempted to pull a car out and was unsuccessful. Now, crazily enough, probably got it right. I mean, crazily enough, like all of this information and basically just this piecemealing of suspicion, this whole situation ends up probably with the driver, which is actually kind of an insane situation that there was actually somebody able to be stopped based on this. But the court said that neither the anonymous tip nor the officer's independent investigation provided reasonable, articulable suspicion to stop. This case is a really important case because we can use it to distinguish from the United States Supreme Court opinion of California versus Navarrete, which goes through anonymous tip situations and basically did a lot of damage, I would say, to the defense in terms of anonymous tip cases. This really scales back from that decision, and the court said, quote, "The anonymous tip reported no crime and was only partially correct, and it merely described the individual as suspicious without any indication as to why," end quote. Quote, "The type of detail provided in the anonymous tip and corroborated by the officers is critical in determining whether the tip can supply the reasonable suspicion necessary for the stop. Where the detail contained in the tip merely concerns identifying characteristics, an officer's confirmation of these details will not legitimize the tip," end quote. So this is really a valuable case in a situation where you have an anonymous tip, because so many times I have seen in practice a call come in and basically report there is a possible drunk driver on the road. The vehicle is a white truck, license plate is X, whatever it might be, all identifying characteristics except for possible drunk driver. But there's no explanation as to why the anonymous caller believes that the driver is drunk. And so when the officer gets up to that vehicle, if the officer doesn't see anything that would indicate that the person is impaired, so none of the 24 clues of impairment identified by NHTSA are present, driving clues or cues of impairment are identified, there's no explanation as to what the anonymous tipster believed was the basis for this driver being impaired, it's not enough. It's just simply not enough. And so if you have an anonymous tip situation, then this is going to be a very helpful case, State versus Carver. Moving on to State versus Orr. This is a case from 2019. It's an unpublished case that looks at weaving as a basis for reasonable suspicion. So normally, as a number of cases, State versus Field, State versus Peel, have looked at, weaving within one's own lane is typically not going to be sufficient grounds for reasonable suspicion to stop. In this case, State versus Orr, the defendant's weaving within his own lane constantly and continuously for a mile while simultaneously coming very near to hitting the curb, crossing onto the center line, and almost causing multiple head-on collisions and forcing oncoming drivers to move toward the right side of their lane created reasonable articulable suspicion to stop the defendant's vehicle. So the reason this is important is that I could see a prosecutor using this case anytime there is weaving within one's own lane to say, Judge, there's a case on point that talks about weaving within one's own lane being enough to stop a driver for suspected DWI. But focus on the facts of the Orr case. There was constant and continuous weaving for a mile. So a long period of driving time, coming very close to hitting the curb, crossing onto the center line. So not over, but onto the center line, almost causing multiple head-on collisions and forcing drivers in the other lane of travel to move towards the right side of their lane to avoid contact. So again, this is extremely dangerous driving that is almost causing injury to other people. If you have somebody that is on a roadway at night, so whether or not this person was impaired by some impairing substance or whatever was causing this driver to be driving that close to the oncoming traffic, an officer likely is making a good call by stopping that vehicle to make sure that a head-on collision does not occur, whether that person is texting, sick, just a horrible driver, impaired, whatever it might be. This is something that the officer is doing society a favor by pulling this person over. So don't let the facts of Orr be downplayed. This was a dangerous situation that was created according to the facts. So it should be relatively easy to distinguish your case from these facts. If you've got a driver that's on a lightly traveled roadway at night, there's no impact on travel. If you've got a person that is driving on the highway and there's no vehicles around your client's vehicle, should be relatively easy to distinguish your case from the facts of State versus Orr. Moving on to horizontal gaze nystagmus in 2019, September 2019, we had a case, State versus Ammons, that talked through the situation of what was going on with a horizontal gaze nystagmus test and whether or not that should have been allowed into evidence. The highway patrol officer testified that he had arrested well over 200 impaired drivers, and that based on his training experience, the HGN test was a reliable indicator that a person was impaired by alcohol. He went on to describe the procedure followed by officers in the field when conducting HGN testing and the results of HGN testing, which led him to believe that the defendant was impaired by alcohol. In this case, the defendant's attorney objected to the testimony. And then basically there was no real tendering of that officer as an expert. The court didn't explicitly say that this officer is an expert in HGN. The Court of Appeals found that the trial court implicitly found the officer was qualified to testify as an expert on the issue of impairment as it related to the horizontal gaze nystagmus. So in a situation where defense counsel objects, the HGN testimony is admitted anyway, the Court of Appeals said this is an implicit ruling by the trial court that the officer is qualified to testify as an expert and the evidence should be allowed. Doesn't have to explicitly tender the officer as an expert in the administration of horizontal gaze nystagmus. So what do we take away from this case? I think that there is a slippery slope kind of that the Court of Appeals is creating, if we want to call it that. But the more and more the court is finding HGN testimony should be admitted. The last several big cases coming from the Court of Appeals and Supreme Court of North Carolina regarding HGN testimony have really not been good for the defense. And so you have to be prepared for that HGN testimony to come in. It doesn't mean you don't attack it. It doesn't mean that you don't do a voir dire outside of the presence of the jury. If you've got a jury trial, it doesn't mean that you don't contest this evidence in district court. You absolutely should in the right cases. But I'd like to offer a different strategy based on the Court of Appeals continually and the Supreme Court continually allowing this HGN testimony to come in. So if the testimony does come in, after you've done your voir dire at district court, the judge overrules any objections that testimony comes in. Here, I think, is a strategy shift. Once the officer has been tendered as an expert, you want to hammer on that. Here is the state's expert. And in this case, members of the jury, this is the only expert testimony that you actually heard. This is the only testimony that the court actually offered as an expert. And in the jury instructions, if there's a special instruction or if there is a standard instruction related to expert testimony, and I think the trial court judge generally says, members of the jury, you have heard in this case testimony presented by an expert. You should consider this evidence along with all the other evidence, blah, 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 blah. If there is that standard instruction on expert testimony, you should ask for a specific instruction that the only expert testimony that was offered was by the officer in relation to HGN. There was no other expert testimony offered. And this is a very helpful strategy where you have somebody that is tendered as an expert in HGN and really doesn't know what they're doing, because this is what the courts have basically allowed for, is that many officers that don't conduct the HGN properly, don't understand what they're looking for on the HGN, still get tendered as an expert, still kind of get through that barrier because the standard in Rule 702 is so low at this point as it's interpreted by the courts of appeal that testimony is likely going to make it into evidence. So once it does, if you have an officer that struggles with HGN, and many of them do because they just don't understand it, then now you can point to the fact, members of the jury, the only expert testimony you heard was HGN testimony. And let's remember, members of the jury, what the officer actually testified to when it came to HGN. And then you go through all of the issues and all of the problems that come. And that's what they're presenting as the best evidence of impairment. That's what they're presenting. That's what the state is presenting as its expert testimony that my client was impaired. In my opinion, this is the Jake Minnick opinion. Most jurors do not buy into the HGN test. They don't. I mean, it doesn't make sense to them. They can't understand it. They can't understand why there would be more value in the HGN test than in the walk and turn, the one leg stand, the way that the person is walking, moving, talking, certainly than the intoxilizer result. They don't have the ability to kind of grab onto anything with that. It's just somebody's eyes moving back and forth. If there's an hour of this ridiculousness presented in the courtroom, and then ultimately they're asked to kind of make that part of the decision. If you can now make that kind of central to the state's case, this expert testimony that's presented on HGN, and this is the only expert testimony that has come in, now it becomes as though that is the best evidence against your client. And then if you're chipping away at that best evidence, it's like, well, dang, if that's the best evidence that has come in, how confident should we be beyond a reasonable doubt that this driver was impaired? So I think it can be a really powerful strategy to, again, knowing that officer is going to get tendered as an expert, overemphasize that piece of things to the jury, specifically where you have an officer get tendered as an expert that should not have been. Moving on, next kind of category that we're going to look at is a couple of cases related to probable cause. So on May the 4th of this year, May the 4th, we've got our Star Wars ruling here in the update. State versus Nazal was decided, and in that case, a probable cause, the court found that a probable cause, in a probable cause hearing, the court is not bound by the rules of evidence. So when it comes to probable cause related to DWI, this is something that I know a number of members of our North Carolina bar have fought very hard to basically require that the rules of evidence be followed in a probable cause, that is probable cause to arrest, not probable cause felony, but probable cause to arrest hearing. And my reading of State versus Nazal is that the court is not bound by the rules of evidence in a probable cause hearing. If you disagree with that or with anything else that I have said, please let me know, because I'd like to correct anything that I am misreading. So if you disagree with that interpretation of State versus Nazal or my interpretation of any of these other cases, send me an email, give me a call. I'd love to talk through it with you. And if I come away from that conversation seeing the light that you propose, I will happily update the listeners on that front. We want to get these things right. And so let me know if you disagree with that. But that's simply the ruling from that case. I don't really have anything else from State versus Nazal. Going back to 2019, we have State versus Fields. This is the December 2019 case. We have another State versus Fields case in the DWI context. So you're going to have to really start mapping out which Fields case we're talking about, presenting to the judge, make sure that the judge knows which Fields case you're talking about. Also, if you have any clients that have the last name of Fields, strongly advise them against drinking and driving. Apparently, Fields isn't, I wouldn't say an uncommon name, but it seems to be particularly prevalent when it comes to DWI cases. So I would strongly advise any clients with the last name of Fields that any amount of alcohol in their system is going to end up poorly. But in State versus Fields 2019, the police received a call to a green pickup truck driving erratically and attempting to hit people. Well, that sounds pretty wild, right? I don't know what's going on here if this guy's just driving on the sidewalk. Officer Macaluso attempted to locate the vehicle and was flagged down by an intoxicated man telling him about the vehicle trying to run people over. Macaluso saw a vehicle that fit the description, I guess a green truck, from dispatch passing by, but the trial court found that Macaluso could not identify the driver. The green pickup truck was not driving erratically at that point or committing traffic violations, and Macaluso did not follow the truck. About 2 minutes later, the defendant approached the area where Macaluso was speaking with a group of people. Macaluso noticed that the defendant was unsteady on his feet, had slurred speech. The defendant appeared angry and complained that he had been sold fake crack, sold the fake stuff. Macaluso called in Officer Munter to investigate the DWI. Munter located a green pickup truck nearby and found an empty bottle of liquor in the back of the truck. Munter conducted various field sobriety tests on the defendant, including the HGN. The defendant showed 6 of 6 clues on HGN, and we know that Officer Munter is going to be tendered as an expert in HGN, so that evidence is coming in. So we got to figure out a way to attack the stop, right? Or the arrest. So the court found that where the officers did not observe defendant driving and the state failed to establish a connection between the driver of the pickup and the defendant, no probable cause existed to arrest the defendant for driving while impaired. This is a powerful case because it is a probable cause case that focuses on the element of driving. So most of our PC cases that we look at, or at least many of them, focus on the issue of impairment. Did the officer at the time of arrest have enough to arrest the defendant based on the signs of impairment that they saw? I don't think there's any question that in this case, the court believed that there was sufficient facts to support probable cause that the driver was impaired, but there wasn't sufficient facts to support probable cause that the defendant was driving. And so that's where this case fell apart for the state and why the court ruled in favor of the defense. Now we have State versus Eldred and State versus Kraft from 2018 that really look at driving when it comes to the close of the state's evidence and where a motion to dismiss would be appropriate. We've actually got another case coming up here in a few minutes that's going to be along that framework. But obviously, the earlier that you can attack a case when it comes to procedural issues, the better. And so now we're basically at the point where there was not even an appropriate arrest conducted because of the lack of ability to show probable cause that the defendant was even driving. So if you have a good driving issue, attack the case first based on State versus Fields 2019, and then attack the case at the close of the state's evidence based on Eldred, Kraft, and let's see, we've got another one coming up here in a second. I'm trying to remember the name of it. I believe it is State versus Nazal. That will be a kind of Kraft Eldred situation. So we'll talk about that in just a second. Last probable cause case, State versus Parisi. This is from August of 2019. This is a case where the Court of Appeals found probable cause existed. And I think you're going to see the prosecution use this case frequently in probable cause issues. Here's the important thing to know if you're on the defense side about State versus Parisi. You got to know the facts. So the defendant was stopped at a checking station. So no bad driving, right? No bad driving. But the stopping officer noticed an odor of alcohol about the defendant's person. So you have odor. The defendant's eyes were red and glassy eyes. The defendant admitted to consuming 3 beers earlier that evening, admission of drinking. The defendant exhibited 6 out of 6 clues on the HGN test, which we know is coming into evidence, right? 6 out of 6 clues on the HGN test, 1 out of 8 clues on the walk and turn, and 2 out of 4 clues on the one leg stand. So the court found that those facts constitute probable cause to arrest. There you go. So, simple holding. But again, I think what a lot of times gets lost in the state arguing PC issues is they don't emphasize enough the facts that were present in the specific case that led to the court's finding of probable cause. So make sure that you distinguish your case from State versus Parisi in terms of what the clues of impairment were that were found by the officer in that case. Next, we've got State versus Terrell, and this is, I would say, I guess, still a probable cause case, but it is also a case that I think is a good Rodriguez, U.S. versus Rodriguez issue that you can bring up in your argument. And so we're going to see this kind of case. I think State versus Terrell, January of 2019 case. This is the case that is probably going to be most helpful to your DWI practice, most helpful to your client's charge with driving while impaired, because of the fact that more and more we have officers that are specializing in DWI investigations. And when somebody gets stopped by an inexperienced or a lesser experienced officer who then calls out the DWI dude to come and do the investigation, this is going to be a case that's going to be helpful in determining how long are you able to keep somebody at the roadside. So first of all, read Rodriguez. Rodriguez is the key to this unlawful detention, the unlawful extension of a legitimate traffic stop. But State versus Terrell really picks up on that, and then picks up on kind of, I guess, uses probable cause. But the question really is, how long can you continue a lawful detention before it becomes unlawful without further probable cause? So in this case, an off-duty police officer was working security detail outside of a nightclub. The officer saw the defendant backing out of a parking space and strike another vehicle at a low speed. The officer did not notice any damage to the vehicle that was struck. The officer noticed a strong odor of an alcoholic beverage coming from the breath of the defendant. Defendant took several minutes to produce his driver's license upon the officer's request. That's great. I mean, that's several minutes to produce his driver's license. I don't think I've ever seen that in a factual case or officer. Several minutes. I mean, that's a long time to produce your driver's license. You watch video of a body camera for 60 seconds and it feels like an eternity sometimes. So several minutes to produce driver's license is odd. So not necessarily the most important fact, but I just found that to be interesting. The off-duty officer interacted with the defendant for, here's the underlined part, close to an hour before requesting another officer to respond. During this near 1 hour period, the off-duty officer testified the defendant was not free to leave, wasn't free to leave. The on-duty officer that responded arrived and looked at the vehicle, took pictures, and did SFSTs with the defendant before placing him under arrest. So what we have here is we have an off-duty officer, notices some unusual behaviors about the defendant, sees this accident, detains the defendant until an on-duty SFST trained officer can come on scene. The on-duty officer comes on scene. He does a full investigation, is taking pictures, doing standardized field sobriety tests, and ultimately places the defendant under arrest. The court held that the 1 hour detention of the defendant constituted a de facto arrest requiring probable cause. While the odor, quote, while the odor of alcohol and the fact the defendant backed into a parked car would have given Officer Artieri reasonable suspicion to initially detain him, these circumstances did not, without more, constitute probable cause to actually arrest the defendant for driving while impaired. And this, end quote. And this is what we see so many times in these cases, right? You have somebody that stopped for speeding. The officer approaches the vehicle. The stopping officer approaches the vehicle. There's an odor of alcohol. The officer might say, well, could you submit to a PBT? Person submits to a PBT. Then they basically say, well, sit tight in your car. Officer goes back to their car. calls dispatch and says, hey, I think I got a possible 1055. I need somebody to come down that can do field sobriety tests. 20, 30, 40 minutes later, another officer arrives on scene. This is your case for that situation. State versus Terrell, along with Rodriguez from the Supreme Court, are your cases to argue. And this is an unpublished case, in case I did not say that before, State versus Terrell, but it is a really powerful case because it lays out the law. It's not really the facts that are primarily important in this one. It really lays out the law in terms of that lengthy detention. In assessing whether a seizure constituted a de facto arrest, reviewing courts should determine whether law enforcement officers, quote, diligently pursued a means of investigation that was likely to confirm or dispel their suspicions quickly, during which time it was necessary to detain the defendant, end quote. That's a key fact to bring out, key language to bring out in your argument. The investigation needs to be diligently pursued so as to confirm or dispel suspicions quickly. The court went on to say, quote, although the length in and of itself will not normally convert an otherwise valid seizure into a de facto arrest, where the detention is more than momentary, as here, there must be some strong justification for the delay to avoid rendering the seizure unreasonable, end quote. And obviously, reasonableness is the touchstone of the Fourth Amendment. So if the seizure is unreasonable, that's where Rodriguez comes into play. It doesn't necessarily mean when you get to an hour detention, now you've constituted a de facto arrest, as the court in Terrell found. But well before you get to a point of a de facto arrest, you're going to hit an unreasonable length of time, which is the Rodriguez issue. That's where this has gone on long enough that the seizure has now become unreasonable, and therefore anything coming after that seizure must be suppressed based on the violation of the Fourth Amendment. Next, we're going to move on to blood draws, State versus Hoke, which is from January of 2020. This is a case about blood draw. If you have a blood draw case, this is a good one to go read in full. But effectively, what this holding says is that the use of force in taking the blood sample in this case was caused by the defendant's refusal to comply with a lawful search warrant and was unreasonable. So many times I'll hear clients call, they have had, they've refused the breath test. Now they're being held down or whatever it might be for a blood draw. And they call in and they basically say, I can't believe that, the state, can hold me down. I didn't think you were allowed to, basically extract blood from me against my will. And this court says, as long as there is reasonable use of force in taking the blood pursuant to a valid search warrant, then use of force is allowed. So again, that may not be how you want to explain it to your client, but it is a case that says that use of force can occur to get blood if there's a valid search warrant and if the use of force applied the defendant is reasonable in response to the defendant's either being complicit in allowing that or fighting with officers to keep blood from being taken. State versus Nazal is from March of 2020, and this is a sufficiency of the evidence case. Again, this is our case that's kind of along the same lines as State versus Eldred and State versus Kraft from 2018. So in this case, Nolasco was involved in a single vehicle accident on I-40 road on I-40. Road conditions were wet and icy. So it was a wet, snowy, icy night. A tow truck came out to address the wreck and was trying to move Nolasco's vehicle out of the roadway. Mr. Nolasco was standing at the roadside when another vehicle traveling on I-40 driven by the defendant hit Nolasco. The tow truck driver went to assist Nolasco. He tried to signal oncoming drivers, but they could not see him, and the tow truck driver had to leave Nolasco to preserve his own safety. Another vehicle came along and also hit Nolasco, and the tow truck driver testified that he believed that Nolasco was dead before the second car ran over Nolasco. The car driven by the defendant left the scene prior to any police arriving. Troopers arrived on scene to investigate the accident and death. Troopers uncovered evidence leading them to believe that the vehicle, which had initially hit Nolasco, belonged to the defendant. They reached out to the Guilford County Sheriff's Office to help in locating the defendant. Deputies arrived at the defendant's residence and found a vehicle matching the description of the one that had hit Nolasco with significant damage. Deputies made contact with the defendant, who indicated that he had been involved in a collision, but, quote, it wasn't a very bad one, end quote. So not off to a good start on the defendant's end. So he drove away. Defendant was initially arrested for felony hit and run, but on the way to the sheriff's office, the trooper indicated that he formed an opinion that the defendant was impaired. The trooper observed the defendant had red glassy eyes, was unsteady on his feet, and at times was, quote, speaking out of his head, end quote, rambling, end quote, nonsensically. The defendant fell asleep on the road to the sheriff's office despite having just received the jarring news that he had killed a man. No SFSTs were performed on the defendant. The jury returned a verdict of guilty for DWI, felony hit and run, felony death by vehicle, and second-degree murder. This is a State versus Eldred and State versus Kraft case, and the court indicated that it based its decision primarily on State versus Eldred from 2018. In its holding, the trial court the Court of Appeals found that the trial court erred by denying defendant's motion to dismiss at the close of the state's evidence on the charges of DWI and felony death by vehicle for lack of sufficient evidence to proceed on those charges. Quote, the state argues that the signs of impairment observed by Trooper Underwood 5 hours later, when coupled with the very nature of the collision, defendant's immediate flight from the scene, and his gross understatement of the collision severity, provides substantial evidence that the defendant was appreciably impaired at the time of the collision. We disagree, end quote. Obviously, this is a pretty serious case when it comes to the facts, right? You have a second-degree murder case in which there is actually a conviction for that, which is not overturned by this decision. So you have very serious facts in this particular case. And I think it's important to point that out. If you have a case that you're arguing this on, you can say, Your Honor, in a case where the court was looking at really what would be kind of the most egregious situation of driving while impaired, which is when somebody else ends up dead as a result of possible DWI, the court really took a close look at the facts and ultimately determined that there was not sufficient evidence, not to convict, not beyond a reasonable doubt, but at the close of the state's evidence, when looking at the case in the light most favorable to the state, there was not sufficient evidence of driving while impaired. That is powerful. That is the power of State versus Kraft, State versus Eldred, and now of State versus Nazal. Because these cases basically look at what is presented by the state and then say, okay, well, let's look at this in the light most favorable to the state and still find that there was not sufficient evidence to proceed forward on driving while impaired. That at the close of the state's evidence, the motion to dismiss should have been granted. So if you have a case that is similar to Nazal, similar to Eldred, similar to Kraft, the recent law from the Court of Appeals on the sufficiency of evidence questions is extremely powerful for the defense. Moving on to jury instructions from April of this year, we have State versus Hernandez. In Hernandez, the defendant was, and this is an unpublished case, the defendant was charged with driving while impaired and requested to submit to a blood test, which she initially refused. After the charging officer obtained a search warrant for blood, the defendant then gave consent for the blood to be searched. So, officer asked to give consent. Defendant says no. Officer goes and gets a search warrant, is getting ready to execute the search warrant. And the defendant says, actually, I'll agree to do a blood test. And so the defense in this case said, you cannot use any evidence of refusal against the defendant because of the fact that she actually ultimately consented to the test, right? I think a pretty good argument in that particular context. The court says disagrees with the defense. The trial court did not err when instructing the jury that they could interpret the defendant's initial refusal of a blood test as evidence of guilt when considered together with all the other evidence, including the subsequent agreement. So the trial court can instruct on a refusal as long as the trial court indicates you must consider evidence of the refusal along with all of the other evidence that you've heard in determining whether or not you find the defendant guilty. And I think that's in the pattern jury instructions when it comes to refusal, is that language that you can take the refusal in connection with all the other evidence that you've heard. And so that's kind of built into the language. I don't think that this was probably a special instruction in terms of the refusal end of things, but the Court of Appeals said it's okay to instruct the jury on the refusal as long as the court is telling the jury to consider all the other evidence of impairment along with the refusal. Finally, we have a couple of cases that are involved in looking at sentencing. So first of all, State versus Altman, we have the that driving while impaired is a lesser included offense of felony death by a vehicle, and the two convictions should have necessarily merged. Pretty straightforward ruling. I'm not going to explain that further. If you have a case where you have a client that's charged with both felony death by a vehicle and DWI, you're not going to get separately punished on those two offenses. State versus Hughes and State versus Magaha. So State versus Hughes is from April of 2019 and State versus Magaha is from November of 2020. Both of these look at the notice requirement of aggravating and grossly aggravating factors in Superior Court. So we're going to look at the procedural history, first of all, of State versus Hughes from 2019. State versus Hughes, the court rules in favor of the defendant. State versus Magaha, the court rules in favor of the state. They're both dealing with the same issue. So these are very factual specific inquiries. And so we're going to look at why there was a different outcome in these two cases. State versus Hughes, here is the procedural history. At district court, the defendant was convicted of DWI, and the trial judge found the defendant to be a level 1 based on the fact that the defendant's driver's license was revoked for a prior DWI, and the defendant had a prior DWI conviction within 7 years. The defendant appealed to Superior Court, and the state never gave notice to the defendant of intent to use aggravating factors. The defendant was convicted in Superior Court, and the Superior Court judge used the same factors to sentence the defendant to a level 1 sentence. In this case, the defense counsel objected to the use of those factors being used in Superior Court, did not in any way stipulate to grossly aggravating factors or to any of the state's lack of notice, didn't agree for there to be a waiver of the notice requirement. And so the court found that when the state fails to give notice of its intent to use aggravating sentencing factors as required by 20-179, the trial court's use of those factors in determining a defendant's sentence level is reversible error. So what does this tell you? The state has to give that notice of aggravating factors. But then we have State versus Magaha from November of 2020. And in Magaha, the requirement of the state to give notice of aggravating factors, the court found, can be waived by defense and was waived in this case due to a couple things. First of all, due to the defendant admitting to the prior conviction, defense counsel stipulating to the defendant's prior conviction, and no objection from the defendant during sentencing that the prior conviction was being used as an aggravating factor. So I think this is relatively easy to conceptualize and figure out what you need to do. But if you have a case in superior court and the state has not provided notice of grossly aggravating or aggravating factors, do not stipulate to those in sentencing. Object to them if the state is going to then argue them at sentencing, because that notice requirement is absolutely required. So object to the aggravating or grossly aggravating factors being used, and then make sure that you continually object to that coming into evidence. So it's not just enough for the state not to give notice. You have to make sure that you're preserving your objection to that being admitted. And I think based on these two recent cases, the judge is going to have a very difficult time in utilizing grossly aggravating or aggravating factors should they come up in your case. So that is it in terms of the 2021 DWI update. Again, we've gone back through the last couple of years. I think we'll make this a regular part of the podcast in the summer, trying to have new cases or recent cases looked into. I will be posting on the blog related to this podcast a summary of all of these cases, as well as the case citations, so that you have the specific cites to the reporters. And we will be updating our lawyers page as well, so that you can have access to these, as well as all of our other case briefs, memorandums, articles, blogs that we have on different DWI subject areas. But we'll be using these cases to update that. To find that page, go to minniclaw.com/lawyers. And that should then take you to our DWI page that is designed for defense attorneys to help prepare your defense on your case. Hope this has been a helpful update, and I look forward to speaking with you next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.